We are in the midst of a series that we began more than a year ago, looking at the amendments to the United States Constitution. One of the enduring features of our government is that our Constitution is able to be amended. As we approach the 250th anniversary of our country, we have only amended the Constitution 27 times. Therefore, each amendment has a story of why was it done, what was the context of the time, and what has it meant for our country as we move forward. Today, we're talking about the 16th Amendment, which permitted specifically the income tax without any regard to population. So if you look at the history, which Dr. James Ely will share with us, we will look at the fact that while the 16th Amendment was ratified in 1913, granting Congress specifically the authority to issue an income tax, there had been other attempts to have an income tax. And each time that income tax had been enacted, it was then repealed. And there's an interesting sort of backstory where some folks think that Congress thought, well, let's try to amend the Constitution. Surely it will never pass. And lo and behold, it was sent to the states in 1909 and passed in 1913. Really looking at a significant change in how the federal government is funded, moving from domestic and international tariffs to the income tax system. In the follow-up to the Civil War, Congress really struggled to bridge the gap between the economic vitality of the East and the North, where the South and the West, which had farming as its principal economic driver, was not catching up. So there was a lot of discussion. And our featured guest today, Dr. James Ely, is a renowned legal historian and a property rights expert whose career accomplishments have been recognized by the significant prizes in his field, the Brigham Cantor Property Rights Prize and the Owner Council of America Crystal Eagle Award. He's the author of several books that have received widespread critical acclaim from legal scholars and historians, including The Guardian of Every Right, A Constitutional History of Property Rights, Railroads and American Law, in which he systematically explores the way the rise of railroads, you can see I'm jumping into the current, railroads shaped Americans' legal culture, and the Contract Clause, A Constitutional History. He comes to us from Vanderbilt University, where he joined that faculty in 1972 and is currently the Milton R. Underwood Professor of Law Emeritus and Professor of History Emeritus. So, Dr. Ely, we are honored to have you with us, and we look forward to you telling us what was going on when the 16th Amendment was passed, and what does it mean, and what does it mean for today? Thank you.
Well, Jane, thank you for that very gracious introduction. And thank all of you for joining while we explore the history and purpose of the often overlooked 16th Amendment. Because the text of this amendment may not be exactly on the tip of all of your recall, let me start by reading to you what the 16th Amendment says. The Congress shall have power to lay and collect taxes on incomes from whatever source derived, without apportionment among the several states, and without regard to any census or enumeration. That probably strikes some of you at least as somewhat odd wording. So To explore that, I'd like to consider with you three questions this afternoon. Why was it thought necessary to adopt the 16th Amendment in 1913? What did the amendment accomplish? And why is it a source of dispute and controversy today? I'm going to have to start by putting this into historical context, which means I'm going to be starting with the Constitutional Convention in Philadelphia. The framers who met in Philadelphia, of course, had a number of challenges and number of dilemmas, number of controversies to resolve in order to come up with a document that could in fact be accepted and ratified. Let's focus on taxation. There was a broad agreement that the Congress under the new Constitution would have to have an independent source of revenue free from state control. It was widely thought that the central defect in the Articles of Confederation was that the Confederation Congress had no power to levy taxes and was dependent upon requisition to the state governments in order to raise revenue. To say the least, this did not work out well. So virtually all of the framers were agreed that Congress would have to have some independent source of effective money raising. Conversely, there was also a great deal of tax sensitivity. The framers were a generation that had just come through a bitter war with Great Britain to secure the independence for the United States. This war was triggered in no small part over a dispute over the authority to levy taxes. And the fear, perhaps exaggerated, but the fear that a remote government in London was levying oppressive taxation on the colonies. Thus, the framers had to walk a fine line. They recognized that particularly unpopular were direct taxes, taxes that were levied squarely on people, as distinct from indirect taxes. Indirect taxes were levied typically on goods or commodities. These took the form of tariffs on imported goods and excise taxes on domestic goods. So the idea was that a person could avoid an indirect tax. You didn't have to buy imported goods. You didn't have to buy whiskey, heavily taxed. But that was an indirect tax as distinct from a direct tax. Now, the opponents particularly were upset that Congress might be able to levy direct taxes on the citizens. So the supporters of the Constitution developed two arguments that they thought would quiet this fear of direct taxation. First, they insisted that Congress would primarily rely on indirect taxes such as tariff revenues, and that Congress would only resort to a direct tax in emergency situations such as war. Now, realizing the sensitivity of this issue, the framers also included in two separate places provisions that any direct tax by Congress would have to be apportioned among the states according to population. In other words, any tax revenue raised from direct taxes must match the percentage of the state's population. This would prevent, they thought, highly sectional taxes, several representatives in Congress from one region getting together to push a tax that would only fall on another region, because any tax, direct tax, would have to be apportioned among all the states according to their population. Now, let me mention several other points here. The direct tax clauses are the only provisions in the Constitution to appear twice. This restriction on direct taxes was deemed of sufficient importance to warrant inclusion in the Constitution at the very time the framers were saying we really didn't need a Bill of Rights. Now, this strongly suggests, to me at least, that the direct tax clauses were intended to have some teeth. They were intended to have bite. They should not be just ignored or construed so narrowly that they have no effect at all. No framer ever said that Congress was to have absolute or plenary authority to levy taxes. Now, bear in mind also that the direct tax clauses do not prevent Congress from levying a direct tax. They simply require that any direct tax would have to be apportioned among the states according to population. In practice, this would be difficult to administer, there's no doubt about that. And in practice, it was to discourage reliance on direct taxes, except, as I said before, in cases of emergency. Now, Congress nonetheless did in fact levy direct taxes at several times in our history. And as the framers had anticipated, it was invariably during emergencies. One example was the war scare known as the XYZ affair, when Congress levied a direct tax. And the other was during the War of 1812, which Congress financed in part by levying more than one direct tax during that conflict. So let's just pause for a moment to reflect how a requisition would work in this context. How would Congress levy the direct tax? Unlike any tax today, Congress would start by levying a gross amount of a direct tax on the United States. Let's say $1 million on the United States. Then the same statute would apportion that $1 million tax among the states according to population. Each state would be assigned what amounts to a goal or a quota. That was their share of the direct tax. The assessed property in each state would be evaluated and the tax collected by officials appointed by the Secretary of the Treasury. Now, it's quite apparent that unless the activity or the nature of the property being taxed was relatively equally distributed among the states, we were going to have a situation in which the tax rate in some state would be higher or lower than the tax rate in another state. As you can imagine, this was not popular, and it made the direct tax, outside possibly of a war context, politically very unpalatable. So the key question was, what's the direct tax? How can we tell a direct tax from an indirect tax? The Constitution offers meager guidance or other direct taxes. In the Federalist Papers, Alexander Hamilton observed that direct taxes, and here I quote him, primarily relate to lands and buildings, but he did not confine taxes to those subjects alone. The Supreme Court first tackled this case in Hilton v. the United States, decided in 1798. This is a decision that warrants careful attention because of its later impact on the evolution of thinking about direct taxes. At issue was a tax on carriages, enacted by Congress in 1794 as part of an overall tax on items of consumption. Now, of course, the tax on carriages is not a hot topic today for debate, but nonetheless, it was a considerably important issue in the late 18th century. The proposed tax on carriages sparked a debate in the House of Representatives over the nature of direct taxes. James Madison spearheaded the opposition to the tax. He termed it unconstitutional. Nonetheless, the House of Representatives passed the carriage tax by a wide margin. David Hilton, a wealthy Virginian, refused to pay the carriage tax on the grounds that it was an unconstitutional direct tax that had not been apportioned among the states according to population. This set the stage for what became a test case. There were a number of unusual features in this case that would later assume such importance. First, it reached the Supreme Court on a stipulated set of fictitious facts. Among these fictitious facts was the preposterous statement that David Hilton owned 125 carriages. Secondly, the government paid the counsel fees for both sides, calling into question the adversarial nature of the parties, and thus whether we have a real controversy here. Was this a genuine controversy or a bid for an advisory opinion? In short, as many scholars have pointed out, Hilton had a strange and problematic procedural backdrop. Alexander Hamilton, now recently resigned as Secretary of the Treasury, argued for the government that a tax on carriages was indirect and therefore constitutional. Of particular interest, again, I think, is Hamilton's definition of direct taxation. He declared that direct taxes included, quote, something more, close quote, than taxes on land. Hamilton explained that, quote, the following are presumed to be the only direct taxes: capitation or poll taxes, taxes on land and buildings, general assessments, whether on the whole property of individuals or on their whole real or personal estate. Clearly, Hamilton did not confine direct taxation to land and stressed that a tax on existing assets would be viewed as a type of direct taxation. The Supreme Court at that time consisted of 6 justices, but only 3, Samuel Chase, James Iredale, William Patterson, participated and authored opinions. As was then the practice, each justice delivered a separate opinion. Each upheld the carriage tax as a tax levied on a commodity and hence indirect. After all, the argument would be you didn't have to have a carriage. Now, despite having resolved the case on this basis, 2 of the 3 justices roamed well beyond the issue of carriage taxes. Consider the most aggressive and expansive of these was Chase's opinion. So let's consider that. Chase posited 2 sweeping propositions by way of dictum. First, he suggested that only taxes which could be readily apportioned were direct taxes. This is reasoning backwards. He ignores the historical evidence that the apportionment rule was designed to discourage resort to direct taxes. The rule was never intended to be reasonable or easy to apply. No one thought it was going to be easy to apply. Chase comes close to saying that the only things that qualify as direct taxes are when it makes no difference. It's no problem applying the apportionment rule. Secondly, Chase seems to propose a frozen category of direct taxes, only capitation and land taxes. But if the framers intended direct taxes to be limited to these 2, land taxes and capitation taxes, they could have just said so, instead of adopting open-ended language, other direct taxes. 2 further observations with respect to Hilton are in order. No justice addressed the question over the validity of an income tax. Not a surprise. There was no income tax anywhere in the United States in that time, nor was there, in fact, an income tax in England at that time. So the mystery, of Hilton is how dicta by 3 justices in a contrived case came to be seen as the definitive interpretation of the direct tax clauses. Following the Civil War, the Supreme Court upheld a variety of new congressional levies against the challenge that they were unconstitutional direct taxes not apportioned. For example, the court sustained a tax on the gross earnings of insurance companies, a tax on state bank notes, the Civil War inheritance tax, and the Civil War income tax, at least as applied to professional incomes. The opinion in these cases were largely mechanical and treated Hilton as having conclusively resolved the issue of the definition of direct taxes. The Supreme Court was disinclined to take a fresh look at the history and purpose of the direct tax clauses and endorsed the narrow reading of these provisions set forth in Hilton. Now, there were always some dissenting opinions if you turn to leading commentators. For instance, the eminent jurist and treatise writer Thomas M. Cooley had a broader conception of direct taxation than did the Hilton court. And his magisterial, a treatise on the law of taxation, 1876, and if you want to Betty buy time reading, you try that one. Cooley defined direct taxes as those which are assessed upon the property, person, business, income, etc., of those who are to pay them. In other words, direct taxes, in Cooley's mind, any tax put on the person directly who has to pay it. As the Civil War era taxes expired, Congress again relied on tariffs to meet the revenue needs, and questions of what amounted to a direct tax faded for decades from public view. But the circumstances would change over time. By the 1890s, there was renewed agitation in Congress to enact a tax on incomes. The People's Party, the so-called Populist Party in the original historical meaning of that term, the People's Party in 1892 had called for an income tax. Now, of course, they were soundly defeated, but the idea was gaining some political attention and currency. Proponents of the levy had a couple of objectives in mind. First, they were mostly anxious to reduce the high tariffs on all kinds of imported goods. And they thought that by taxing income, they could create an alternative source of revenue which would permit reduction of the high tariff. Noteworthy that the income tax in 1894 was in fact an integral part of a tariff reform bill. There was also the question about distribution of wealth. Although this seems to have been a secondary objective, nonetheless, there were concerns that wealth had piled up very heavily in a limited number of hands, many of them based in the Northeast and not in the South and West. And therefore, there was a kind of a redistributive edge to the income tax. After a bitter debate with sectional and partisan lines flaring, Congress enacted our first peacetime income tax in 1894. Now, to modernize, this tax was pretty modest. The tax was a flat tax of 2%. How do you like that compared to today? A 2% tax on individual incomes over $4,000 a year. But bear in mind that most people didn't have a $4,000 a year income in the 1890s. In fact, you were pretty well off if you had a $4,000 a year income. It was indeed anticipated that a relative handful of people would pay this tax, and most of them resident either in the northeastern states or in California. Well, during these debates in Congress, several members of Congress expressly asserted that in their view, the proposed income tax was a direct tax and would be struck down as unconstitutional because it was not apportioned among the states according to population. But you couldn't really, as a practical matter, apportion the income tax in 1894 according to population. Most of the people who had to pay these taxes were concentrated in a relatively small number of states. There was apparently nobody to pay this income tax in some states. So how that could be apportioned is unclear. In fact, I think apportionment was the death knell for the income tax. So opponents wasted no time in launching a constitutional attack. And in April of 1895, Chief Justice Melville Fuller, speaking for a 6-2 majority of the Supreme Court in Pollock v. Farmers Loan and Trust, ruled that a tax on income from land was the equivalent of a tax on land and was therefore a direct tax. Mind you, bear in mind, most everybody had agreed that a tax on land was a direct tax. And so what Fuller said was a tax on income from land was a direct tax. In the course of reaching this conclusion, Fuller made the first serious judicial effort to probe the history and purpose of the direct tax clauses. He concluded that the rule of apportionment had been added to the Constitution as a compromise in an effort to guarantee ratification in the face of intense popular opposition to allowing any direct taxation by Congress. The court was equally divided with respect to the validity of an income tax on other matters, such as income from personal property. That, even in those days, would have probably meant investment income. So the case was re-argued. A month later, again speaking through Fuller, the court struck down the entire income tax. Fuller relied on Hamilton's argument in Hilton that direct taxation included general assessments upon one's property. He reasoned that an income from personal property should be treated in the same manner as an income from real property, and they had already decided that that was invalid. Turning to Hilton, he pointed out that Hilton was a case that, in fact, only decided a tax on carriages was indirect. That was no longer a topic of great interest by the end of the century. He accepted the Hilton notion that a tax on land was direct. What he simply did really, was to reject the sweeping dicta about the scope of the direct tax clauses. He also pointed out that this was not set in stone, that a constitutional amendment could confer authority on Congress to levy income taxes, and of course that states were free to levy income taxes. The direct tax clauses only related to taxation by Congress. There were dissenting justices who wrote impassioned opinions. They relied very heavily on Hilton, did not do much fresh analysis, and on the notion of stare decisis. Now, the Pollock decisions aroused a firestorm, there's no question. There were certainly vitriolic critics and also strong champions. Critics immediately called for a constitutional amendment. In fact, William Bryan, in his famous campaign, the so-called Free Silver campaign, urged a constitutional amendment to allow an income tax. The election of Republican William McKinley as president in 1896, a rather sweeping victory. Both houses of Congress went to the GOP. That doomed the tax for nearly 20 years. It largely fell off the political agenda. By 1904, none of the major parties were any longer calling for an income tax. But public attitudes changed, as we will see shortly. Interestingly, the Supreme Court upheld other types of taxes against a direct tax challenge. They upheld, for example, the federal estate tax, or inheritance tax as it was in those days. And they also upheld a corporate income tax as an indirect tax. But as we move further into the 20th century, and the so-called progressive movement gained political ascendancy, there was a renewed interest in an income tax. Yet Pollock was an obstacle, and this posed a dilemma for the proponents of the income tax. Some said, just have Congress enact a new income tax. We'll take that challenge to the Supreme Court, and we'll put the Supreme Court on the spot. Will they affirm Pollock, or will they overrule Pollock and uphold the new income tax? But there was a risk there. Some feared that if the Supreme Court, in fact, reaffirmed Pollock, that would doom the income tax. That was a risky strategy. So they preferred a different approach. They preferred the constitutional amendment. But here too, there were concerns. It wasn't necessarily obvious that necessary number of states would ratify the proposed 16th Amendment. And so they didn't know which way to turn. President Taft may have made the decisive voice here when he preferred the constitutional amendment approach. I think he, in part, a person who strongly believed in judicial integrity, he was bothered by the idea of directly challenging the Supreme Court, thought the most appropriate and orderly way would be pursuing Fuller's suggestion of 20 years earlier to pursue the amendment process. It is true that some members of who favored the amendment process may have secretly hoped it would fail. That probably is true in some cases. But in fact, the majority of people who preferred the amendment process, I think, in fact, wanted it to pass. They thought this was the better route. Now, let's turn to consider the debate over what would become the 16th Amendment. The 1909 debates are revealing as to its purpose. The leading sponsor emphasized that the amendment was confined to empowering Congress to levy an income tax. A more radical proposal was floated. This was to eliminate the direct tax clauses from the Constitution altogether. Just be done with them. This was decisively defeated, apparently by voice vote. Had this passed, if the amendment said this, it would have allowed Congress then to levy any type of tax without apportionment. As adopted, however, the 16th Amendment was directed at important but narrow provisions, simply superseding Pollock as a barrier to a federal income tax. It left the direct tax clauses otherwise untouched. The 16th Amendment passed both houses of Congress by wide margins. State ratification proceeded slowly, but in the end, by 1913, it was completed in February of that year. The validity of the income tax is really no longer an issue. Of course, we haggle over details endlessly. I haven't got time to go into that. Yet the 16th Amendment has raised a number of questions with contemporary relevance. What constitutes income? Who's to decide the meaning of taxes on income? The Supreme Court addressed these issues in the leading case of Eisner v. Macomber, cited in 1920, which involved an effort by Congress to tax the cash value of stock dividends. The court ruled, 1, the 16th Amendment merely applied to income, and that the direct tax clauses retained an important function with respect to direct taxes on real or personal property. 2, courts were to decide the meaning of taxes on incomes. Congress was not free to impose its own definitions or to determine the meaning of constitutional norms. 3, a stock dividend was capital, not income, and a tax on stock dividends without apportionment violated the direct tax clauses. Other court decisions in the 1920s similarly insisted that under the 16th Amendment, Congress did not have carte blanche to define income, so it could not declare anything it wished income and is thus taxable under the 16th Amendment. Recent proposals in Congress for an unprecedented tax on wealth have brought the 16th Amendment and the direct tax clauses into contemporary focus. Flying in the face of Eisner, some scholars have contended that the 16th Amendment conferred on Congress the power to define the meaning of income. The Ninth Circuit Court of Appeals reached a similar decision in Moore v. United States, a case now pending before the Supreme Court. Upholding a tax on unrealized gain on foreign investments, the Moore Court emphasized that the 16th Amendment vested in Congress the authority to define income. This ruling could, in effect, of course, bypass and effectively eliminate the apportionment requirements from the Constitution. It occurs to me that words like direct tax and income, if they are to have no discernible meaning, it's reminiscent of Alice's adventures in Through the Looking Glass. There she is advised by no less a linguistic authority than Humpty Dumpty that when I use a word, it means just what I choose it to mean, neither more nor less. To which Alice replies, the question is whether you can make words mean so many different things. The notion that constitutional language has open-ended meanings to be determined by legislators strikes at the heart of a written constitution. In contrast, I would argue that the 16th Amendment overruled Pollock only with respect to income taxation and left other direct taxes subject to the apportionment rule. Well, I thank you for your attention. I realize that, as Mark Twain once said, being talked to death is the worst way to go, and professors can be guilty of that. So with that, I will say thank you and wait questions and answers.
Jim, you are a great storyteller. You really,
Thank you.
try to talk about what does this tax mean and, how do you make it go? So tell me this, how did the shift, and please, we invite our folks to send in your questions to the Q&A. I'm just going to get it started. How did the shift in government funding from tariff-based to individual income change the power between the federal government and the states?
That's a very interesting question. In fact, Pollock's opinions, he puts a good deal of attention to state-federal balance and suggests that opening a federal income tax will create a new source of revenue that will distort the federal-state balance. So I think that's a very, very fair point. It's when the income tax was first enacted, even most of its proponents didn't believe that it was going to become the primary source of federal revenue. Throughout most of the 19th century, the government had financed itself largely with tariff revenue. And indeed, in the 1890s, the government was running a surplus. There were debates about the surplus, not our endless debates about deficit. And of course, the critics of the income tax said, we don't need another tax. We have money sitting in the bank now. That would change very quickly after 1913, because whatever the proponents thought, circumstances were going to spin out of their control. 1914, World War I breaks out, and the United States enters that war 3 years later, and the income tax became increasingly a major source of revenue. Besides, tariff revenue was cut off rather dramatically with wartime shipping, brought back almost to a standstill. So the income tax emerged as a major source of federal revenue, and of course has remained such ever since. Secondly, I think your question about federal-state balance is a very good one. There are a number of ironies here. I could tease some of these out. Most of the people who were really enthusiastic about the income tax, as more than one humorist pointed out, came from the very states they weren't going to have to pay it, whereas most of the senators and representatives who were violently opposed came from states where it was going to be an income tax liability. Secondly, for many years, as you know, senators from the southern areas were purported to be great champions of states' rights. They were constantly concerned about increasing federal power over this, that, and the other. They opposed national bankruptcy in part because national bankruptcy was going to create federal power. And yet they all voted for the income tax, which did more than any of these other things to alter the federal-state relationship, because it gave the federal government a whole new source of revenue from which it could undertake many more activities. But anyway, I didn't mean to digress, but your point's a very good one.
Well, now think about, where we are now. The history of the creation of the income tax, in large part, I think, and tell me if you think I'm wrong, scholars would say that it was a progressive era result. And we had orators like William Jennings Bryan who were advocating for it. We had folks, advocating for it outside of the political system to move the process. Now there's a conversation about a wealth tax. How are those different?
Well, an income tax falls on what a person has earned, either through their labor or through their investments. A wealth tax would relate to your existing assets.
And do you think that Congress under the 16th Amendment has the power to enact a wealth tax?
No, I do not. I think that the 16th Amendment said that Congress could tax incomes, and they can tax incomes in any number of ways, but ultimately it has to be income, not capital.
And now, would you like to comment on the advent of the earned income tax credit? And how has that sort of changed the dynamic of the income tax as a tax, so that it's both a tax and a benefit program?
I'm afraid I'm going to have to take a rain check on that one. I'm not particularly expert on the credit, the income tax credit. My background is primarily in constitutional history, and when you get to contemporary questions of the minutiae of different tax laws, I would have to pass the cup on that one.
That's fine. That, that's all good. Now, let's go back, to the time when the constitutional amendment was proposed. There were some discussion at the time of the 15th Amendment about whether there would be something in the 15th Amendment. Was there any conversation about an income tax in the context of the 15th Amendment, or was it completely distinct?
Well, I have not read the debates on the 15th Amendment. I have read the debates on the 16th. Nobody made any reference to the 15th Amendment that I saw. So I think they would have been completely separate. The proponents of the 16th Amendment, the leading proponent was a Republican senator from Nebraska. He was pretty clear what he was trying to do. He was trying to overturn the Pollock decision so that Congress could tax income without regard to apportionment. That was a very important step, but it was also a narrow step.
Mm-hmm.
And he fended off, as I mentioned, he fended off proposals to make more radical steps. I think he wanted to focus on the issue at hand rather than open Pandora's box to what else might come along.
Now, let's go back for a moment. 1789, the first year after the Constitution took effect, Thomas Jefferson wrote a letter to James Madison, and he said, "Every constitution and every law naturally expires at the end of 19 years. If it is to be enforced longer, it is an act of force, not right." Now, we're coming on 250 years of our Constitution, and we have many laws that have gone well past 19th. What extent do you think the framers' original idea that this was really kind of a short-term situation? Is that anything you want to opine on?
Well, I will opine to this sense. Jefferson, of course, technically speaking, was not a framer because he wasn't at Philadelphia, and he did have various notions. I'm not a Jefferson scholar, but he did have various notions about time limits to laws and to Constitution itself. I think the majority of the framers, first of all, thought that the document would last longer than the Jeffersonian period of 18 years that you mentioned. Secondly, however,
that's one generation. I think that's where the
one generation. Yeah, I think they were thinking longer term than that, but they did not think that their work, as it came out of Philadelphia, was to be the final word. You've already alluded to the fact earlier in your comments that our Constitution specifically provides for amendment. And in fact, there have been a number of amendments in response to various types of issues and pressures over time, various amendments that have made significant changes in the Constitution. So I don't think they ever envisioned that their work was going to be fixed in perpetuity. I do not know what the framers would have thought about an income tax or a direct tax in the early years of the 20th century, but I don't think that they would have said that you could not amend the Constitution to provide for one. So I think they actually provided a mechanism a for flexibility, if you will, in the constitutional document.
And the United States is the only developed country whose income taxes income from across the world. Has that has that ever been challenged to your knowledge in court? Are we able to tax income generated in the United States? My understanding is we now tax income generated worldwide. If you're an American citizen, you'll pay.
If you're an American citizen, I had the pleasure of spending a year in England teaching teaching a year in England, and I had to pay a U.S. income tax. Yes, you're exactly right. I'm familiar with the downside of that rule. Yes, but you also are correct. I had an English friend who was teaching in the U.S., and he told me that if he was outside of England for a full 12 months, he didn't pay any income tax that year. That's not the rule here. I don't think, though, my best guess is that could not be successfully challenged. I think Congress has wide latitude how it wishes to tax income. I'm only drawing the line, you can't confuse capital with income. I think Congress can tax income, and if you're a U.S. citizen and presumably have the advantages of U.S. citizenship, and you go to a foreign country for a year and earn a salary, they will tax it, yes. And I think that's pretty well settled.
Settled law. So the fundamental difference is that the 16th Amendment allowed the federal government to tax income, not land, not property, not capital. And those matters are are often taxed by local governments or state governments.
Correct.
Where you have property tax. So by doing that, the federal government sort of was able to, didn't have to opine on the question of what was property and what was appropriate, right?
Well, you've raised a very interesting point there, because it came out again and again that state governments, even in the colonial period, they relied very heavily on taxes on land. That was their bread and butter. That's how they existed. And among other arguments against direct taxes was, you're going to destroy the tax base, the revenue base for the states, which incidentally raises the federalism issue that you were posed a few minutes ago. And there was great sensitivity about a tax on land. In fact, at the same time that the Congress voted the carriage tax, there was a proposal to tax land, and that was overwhelmingly defeated in the Congress. To my knowledge, it's never really resurfaced, and I don't see that as being a crowd pleaser, but maybe I missed something.
Well, I come out of local government, and
yes,
we preserve the property tax for our schools and our human services.
Well, of course, property tax is essential. I served for some years on the planning board of the town of South Bristol, New York. I know you've never heard of it, but I mean, I didn't have anything to do with taxes directly, but obviously the real estate tax, that's what funded our little town, paid for our schools, and our snow removal was a big issue for us, and those kinds of things. But little services we offered had to be paid for.
Exactly.
So we couldn't, if the federal government piled on top of tax on top of that, it would be, I think, a very serious problem for local government.
So walk us back to 1913. We now have passed the 16th Amendment. How did the federal government go about collecting the tax? I mean, we all know that the IRS and the,
yes,
1099s and 1040s and blah, blah, blah.
Very good question.
What was going on with all that?
Let me come to that. Let me come back to the Civil War income tax, which was enacted during the Civil War, obviously. And that was the first experiment with an income tax. Now, the Civil War was clearly an emergency, so it fit one definition of when you would have a direct tax. The Civil War income tax, they didn't have anything like the Treasury arrangements we have today. Nothing like it at all. To a large extent, it was almost an honor system. There was some enforcement mechanism, but basically, citizens would feel it was their patriotic duty during the Civil War to pay their share of the income tax. And it did raise a certain amount of revenue, worked surprisingly well. But the Civil War income tax was never the biggest single source of government revenue during the Civil War. Yeah. And it did expire. It was unpopular after the war, and Congress let it expire. So by 1913, Congress has to enact and does enact a whole enforcement apparatus of income taxes, and they impose an income tax. I mean, the amendment only says Congress has the authority to do it. Then Congress actually has to do it. Right? And Congress does enact a tax in 1913, our first permanent income tax, if you will. And they do create a enforcement mechanism. I can't speak to the details of that, but they do in fact create people, officials whose job it is to enforce the tax.
And
of course, today it's spun into this, substantial bureaucracy of the IRS.
And, at the time it was enacted, you talked about the $4,000, threshold being
Yes.
the wealthy individuals who were at 4,000. Do you know at what point did the creation of the, different levels of taxes based on your income? When was that?
I believe that was introduced in 1913 when with the first tax under the 16th Amendment. They made them more progressive. The 94 income tax was not progressive in the modern sense. It was 2% flat tax.
Okay.
I think some of our states may have a flat income tax. I haven't really studied it, but Congress has long had the tiers of brackets, if you will.
And so even at the time the 16th Amendment was passed, there was discussion about it being a progressive income tax.
Oh yes, I think so. I think there definitely was discussion along those lines, and I think in fact they enact. I'm sorry, I don't have it right handy here, but they did in fact in 1913 impose a progressive scale. That is to say, the more income you had, the higher your tax rate would be.
Right. Well, we're coming to the end of our time, and we're so honored, Jim, that you've been with us and you've offered your time, your talent. And so let me just offer you one last question, and you can, take it as you may, because it's a little bit about modern times. There are two things that, nobody loves taxes, right? Let's understand that. But there are two kind of things that people talk about that are challenging. You've got the DC folks who have taxation without representation, and then you have this emerging group of people who are moving around state to state in order to avoid the state income tax. It's not a federal tax, but people are figuring out, can they spend 180 days in Florida or Texas or somewhere else? Has there been, do you have any thoughts about what the framers of the 16th Amendment would feel about either of those two things?
No, I'm afraid I don't really. The District of Columbia, after all, they people do choose to live there, and they know the status of the District of Columbia, and so I don't think the framers. First of all, there was no District of Columbia at that time,
Right.
And then by the 16th Amendment there was, but it's much larger now in terms of population than it was in 1913. I don't think they focused on that at all. As far as moving around, moving with your feet, as some people, voting with your feet, as some people say, yeah, that certainly is a phenomenon right now. And where I am in New York, we have what they call them snowbirds. A number of people, I know some personally, who go to Florida for a little over half the year, and they have developed this to a pretty sophisticated arrangement. And that doesn't really involve, of course, a federal tax at all. So I doubt the 16th Amendment people would have focused on that. Some people would say that's kind of what the nature of federalism. You can move to a more congenial climate if you wish, and that's good. A number of policy issues could dictate where you choose to live, and taxation could be one. But I'm afraid I can't help you beyond that.
Well, you know what? We are so gracious to hear from you and to put this whole conversation in context. We are grateful for your time, for your talent. And we are grateful most especially to our members and supporters who allow us to put on public history of this kind. As you may learn now that you're part of our United States Capitol historical family, we were chartered by Congress to provide information, education about the Capitol and the people who work there in a manner that inspires informed patriotism. And you have certainly contributed to that effort. Looking ahead, we have a webinar coming up in March, both Thursday the 7th and Thursday the 14th. We'll be looking at the work of Senator Frank Church with a newly released book, The Last Honest Man. The CIA, the FBI, the Mafia, and the Kennedys, and one senator's fight to save democracy, with the authors of that book. And then we turn to the 17th Amendment, the direct election of senators. And we'll have our guest that day will be Senate historian. So each of these is available to anyone. Our program is recorded and will be available on our website. Our YouTube channel has a wealth of information. If you can't catch it, or if you caught it and you said, oh, I know someone who would love to hear this, it is all available to us and to you and to share. So thank you, Jim. Appreciate you being with us. Thank you for your contributions. Keep those contributors coming. We look forward to seeing you in March. Be well. Goodbye.
Goodbye. Thank you.